Next case is State of Ohio versus Michael Elek. It is case number 20CA011611. Same panel, Judge Hensel, Judge Sutton, and myself. I'll be keeping track of the time, so if you're going to save time for rebuttal, let me know and I will let you know as you approach that. Same rule that you both are aware of. If there are children or minors or victims involved, we ask that you not refer to them by name, but use initials or some other reference, a child, for instance. We've read the briefs and we are prepared to proceed. Would you like to reserve some time for rebuttal?
Yes, 5 minutes, please.
5 minutes, I'll let you know as you get close. All right, you may begin.
Thank you, and may it please the court, my name is Stephen Hanadel. I represent the appellant Michael Elek. Mr. Elek was charged with 4 counts of sexual offenses, and they allegedly involved two different incidents, years apart. So 2 of the charges were severed. Count 1 and 3 were severed. 2 and 4 were shelved until later. So Mr. Elek first went to trial on count 1 and 3. He was acquitted of rape, but he was found guilty of gross sexual imposition, which is subject to this appeal. And then later on, he was tried on the other 2 counts, but the jury hung on both those counts, and which the state elected to dismiss those charges after the jury failed to reach a verdict. So, despite all those allegations, there only just this one conviction of gross sexual imposition, and which, our position is that first, the evidence is insufficient. The allegations were reported many years after the fact. They arose when there was some family disputes with the people that were staying with the Eleks, and I believe that SW's, it's her mother or stepmother, I'm trying to remember, but was staying with Michael and Jennifer Elek, and it's when the fact that the mom wouldn't do anything to earn her keep there, and finally Michael Elek was upset enough to where he wanted her to leave. And it was after those confrontations, which got very heated, that suddenly these allegations were reported to police. And so I think the court needs to consider that. And when it comes to sufficiency, I think there's got to be just more than just mere allegations, because especially in a case like this, when it's reported many years after the fact, allegedly the fact, and it's just he said, she said, and there's no other corroborating evidence. I think that the court's got to take a look at what is sufficiency, because the fact that someone can just merely throw an allegation at somebody years later, that should not constitute sufficient evidence. There's got to be more corroborating evidence, whether there's some kind of documentation, or or if the accuser is able to elaborate on details that can be verified through other records, and none of that's the case here. It's just, and these allegations are very vague, and it's very difficult to tell whether is she making it up or are they real. And like I said, there's such a lack of detail and a lack of corroboration. And there were allegedly 2 other people that SW had told at the time, but neither of them testified. So it's just this smells more of retaliation against Michael Elek for kicking out the mom who was staying there and was just doing nothing but laying on the couch and doing nothing. And so, and he had, the fortitude to just defend his household. And next thing you know, he had kids.
Attorney Riley's going to respond that, hey, these are jury questions. They make those decisions, and that the testimony of a victim is sufficient to prove that case. Isn't that the status of the law?
But I think the court has to take greater care with sufficiency in these types of cases, because given, especially in our climate with the Me Too movement, we just had the Johnny Depp trial that ended in a verdict, and there's all kinds of just everybody's blown up on social media about that. And I think that, you know, the trial courts have to take greater care to make sure that what is being forwarded to the jury has some substance to it. Truly, it has some verifiable substance, you know, and I get it where it's construed in favor of the state, I get that. But here, it's just mere bald allegations that were so many years afterwards. I mean, I think it was 6 years after it allegedly happened, and just no corroborating evidence. There's no, like, you know, time records, or whether, you know, it was somebody at work, or somebody at school, or somebody, you know, the weather that day, or just anything. It's so bland and so vague. And like I said, even the two people that SW allegedly told this to weren't present at the trial to testify. And so there's no written diary. There's nothing no contemporaneous corroboration of these allegations. And I think the courts really need, when it comes to these types of cases, because the nature of these allegations hit such a raw emotional nerve to so many people out in the community, and especially the juries, that the courts have to take greater care to make sure that these types of charges being forwarded to the jury have some verifiable corroboration for them to be sufficient. And if I can then move on to the next issue, the second assignment of error. The trial court allowed the state to admit this list that Jennifer Elek, Michael's wife, had written at the time for her own therapeutic purposes, because, you know, she's hearing these allegations that her husband allegedly engaged in this behavior, and she doesn't know what to think, and she's trying to figure out what's going on, so she seeks professional help of a therapist, and you know, I think we should applaud her for that, because so many people don't. They bottle up their emotions. So the therapist gave her recommendations and tried to help to work through how she's feeling, and so she wrote this list down. And it's all hearsay. None of this was anything that Jennifer herself witnessed. And the state tried to say, oh, well, you know, we admitted under Rule 613, I believe, yeah, B2A. Now, they don't argue B or C. They say letter A under 613 B2. But they're saying, well, we're just impeaching her testimony, saying that she never accused Michael of engaging in improper sexual behavior. But they admitted it for much more than that, because, and it wasn't, and also, that list was, as I said, the list was pure hearsay. That list was not admitted, that Jennifer wrote that list for her marriage counseling purposes, not for the truth of the matter asserted, which is the key point, because hearsay has, the state ultimately brought that in as hearsay to prove the truth of the matter asserted, and they tried to cloak it as, oh, this is just to impeach her testimony that she never accused Michael. It was more than that, and plus, the list wasn't really an accusation. The list was just merely her thoughts of what she had heard from other people, but it wasn't Jennifer accusing Michael. So the state's argument failed on that point too. That this was not. When she said that she never accused Michael, that very well could have been true, and that list does not disprove that, because, again, it's just, she's not accusing Michael of, oh, you did this, I saw you do this. It's just writing down what she had heard from other people. And because the state also, in their rebuttal presentation, they brought in testimony of rebuttal witnesses who did not testify in her case in chief. The rebuttal witness was there solely to impeach Jennifer's testimony, but yet they brought out more than that. They brought out testimony from the rebuttal witness that SW had told her that she had been touched, which was never alleged in the state's case in chief, as far as as far as testimony from a corroborating person. And again, that's just all hearsay. It's all brought in to prove the truth of the matter asserted. And because beyond that, the state had nothing else. Beyond this list, the state had no other evidence to corroborate the accusation. And so this list was definitely had an impact on the jury. So when the jury is looking at this like, well, who should we believe? That list makes a difference. It tips the scale. And so, and again, that list is 100% hearsay. None of it contained Jennifer's firsthand knowledge. It's all what she had heard from other people without any kind of verification or corroboration. And she wrote that down simply to address her concerns to a marriage counselor. And that's it. And that's just not probative evidence as to whether Michael has committed these offenses or not. I mean, it's just merely reflective of a concerned wife, you know, trying to figure out what the state of her marriage is. And because whether any accusation, whether if it's true or false, is going to rock a marriage, it's gonna make the spouse wonder what is going on here.
So the list was used to impeach the defendant's wife's statement that she made at trial. So it was used, how does that affect the victim's credibility?
About Michael Elek's statement?
Yeah, the wife had testified a certain way, and they wanted to use this list
Right.
to impeach
Her.
her credibility. You still have the victim. I mean, does that go to the victim's credibility? You said that, you know, that affected. I'm looking at the prejudice argument.
Sure. Well, because
Help me out with that.
it doesn't go to his credibility because she's writing down things that she just heard. You know, these accusations come out. She's writing down what is swirling around, and again, it's just it's.
She had testified she'd never accused that. I lost that. That's what
Yeah.
you said. She had testified. They're using that to impeach her statement that, you know, hey, she never accused Michael of committing these acts. I can see where that could go towards. I mean, let's say it goes to attacking her credibility. And where's the prejudice there, since he's not really, this doesn't affect the credibility of the victim who testified all of this happened? I guess that's my question.
Well, ultimately, it affected Michael's credibility at the end. I mean, as far as his defense, because when all he could say that I didn't do this, I didn't commit these acts, and unfortunately, because the fact that these allegations were reported so many years later, I mean, that hurts his ability to defend himself too. And so, because who knows what records he could have had that he might have thrown out, or you know, trying to think back. Well, gee, what like you know, was I at work at that time and stuff? Because he testified that he often worked the night shift. Now, as far as whether
I'm going to stop you because I just noticed that I was so wrapped up in the argument.
Sure.
You're down to like 3 minutes.
Okay.
For your rebuttal.
all right, I'll save it.
You want to save it? Okay.
Yeah.
And thank you for your answer. That helped me out. And I apologize, but I was wrapped up in your argument there. So you'll have 3 minutes. Counsel, you'll have 15 minutes.
Thank you again. May it please the court again. I'm Rick Raley here appearing on behalf of the Police State of Ohio and Lorain County Prosecutor Jaden Tomlinson. Like the other case we argued today, I think there's no error in the trial court today. You should affirm Mr. Elek's conviction as well as his sentence. And I'm going to start out with the sufficiency and manifest weight issues that are raised in the first and third assignment of error. And really, for the sufficiency argument, I think it's essentially been waived. There is clear evidence from the victim's testimony that every element of the gross sexual imposition occurred. She testified directly to it in page 255 to 260 of the trial transcript, and there's just no question that occurred. The appellant, in his argument as to, well, what is sufficiency? We know exactly what a sufficiency argument is in the state of Ohio. It's been this way for decades. There's clear case law indicating you don't need corroborating evidence from anybody for a sexual offense or any type of offense. So period, that's established. So these arguments really they really sound in manifest weight. And I will concede this is a case that relies heavily on the testimony of the victim. But there's no indication in the transcript that her testimony is incredible. The defense attorney at trial even remarked in closing how well she presented. Nothing was elicited during cross-examination that indicated motive to lie. There wasn't, during appellant's presentation right now, that this may have been some sort of retaliation for kicking the victim's mother out of their house. These allegations weren't actually brought to the police until 8 years after the fact, after She had already been removed from the Elek's house. And she didn't seek out the police came to her. So she had no motive to go against Mr. Elek. She had already moved on. And that came out of trial. This is an interesting case too, in that the defendant did testify, and the jury was able to consider both of them testifying, which one seemed credible to them, and apparently they picked the victim's testimony, and there's really no reason to disregard that on appeal. But also, it's very critical, I think, in the defendant's testimony that he never actually denied anything about this account. He wasn't asked any questions about it. And in fact, the defense case, and it's continuing here on appeal, is essentially, well, the victim's mother isn't a very good person, and there's all these kinds of issues surrounding the victim's mother. How does that relate to the victim's testimony? If anything, it actually enhances her credibility, because those issues with the mother explain why there's a delayed disclosure. I'd also note for the record that the defense, and the only reason I'm bringing this up is the defense lawyer brought this up at trial. He elicited testimony about an inconclusive polygraph result involving the defendant, and that he refused to go for a second one because he didn't have a lawyer. So the jury heard all of that, concluded that the victim's testimony was more credible. Now, moving to this second assignment of error, the evidence rule 613 issue, I think it's very important to note there was not an objection about the admission of this evidence. The state raised that it was going to call, her name was Ms. Healy, she was going to testify about this list, and the list itself was not admitted into evidence. It was State's Exhibit 1. They brought that they were going to call her as a witness. The defense counsel never lodged an objection. During her testimony about this list, defense counsel lodged an objection about a lack of foundation for who was the author of this. The trial court sustained that objection. Next question laid the foundation for the question. Testimony continued on. Ms. Healy's testimony is 2 pages.
No further objection.
No further objection. Ms. Healy's testimony was 2 pages long in this transcript. There was no cross-examination of her. That's because there's no material import to her testimony. This is about the victim's credibility. This list has nothing to do with it. It was, and in fact, the wife who wrote this list was cross-examined about it exactly. And she testified to everything that was just brought up. Well, it was just stuff I had heard. I didn't know it was true. I wrote it down for my own marriage counseling purposes. It really had no impact on anybody's judgment of credibility then. Really, the only purported prejudice that defendants identified in the brief is that this must have made the jury believe that the defendant was some sort of creep and that he must have done something. If a jury was so inflamed that way, it's hard to believe they would then go ahead and not guilty one of the counts. If they were inflamed, they would have convicted him of both. In light of that, I think that there's no prejudice on the second assignment of error. This court should overrule that and sustain that issue as well. And there's also a sentencing issue. Again, the fourth assignment of error, there's no evidence in the record that that sentence clearly commits the contrary to law. And I believe the sentence is also legally sustained and should be found appropriate. So if there are no further questions, Your Honors, I would ask you to overrule the assignments of error from the trial court.
On the third assignment of error, does the record show that the court considered all of the sentencing factors?
Yes, there is. It's the indication that they understood the victim was a traumatized 15-year-old, that she had this offense committed against her while she was basically by her step-uncle, while she was in the care of those people when her mother lost their house. She had to barricade herself into her bedroom at night with a toy box to stay away from them. Based on those facts, I think an 18-month sentence is perfectly appropriate.
Judge Hensel? Judge Stein? All right, thank you for your argument.
Thank you, Judge.
Attorney Hannibal, you have the 3 minutes and 6 seconds. You can look at it 2 ways. I gave you a little bit more time during your original argument, but you're stuck with 3 minutes and 6 seconds.
I'll just address one quick thing on the second assignment of error. First of all, I think the trial counsel made a sufficient objection, so therefore the burden is on the state to show that the error was harmless. But nonetheless, I've laid out that it's also plain error too, because admitting that list did affect Michael Elek's substantial rights to a fair trial, because that list, like I said, that pretty much broke the tie between SW's accusations and his denials, and there was nothing else presented that went to one side or the other. So that list, as far as the jury was concerned, they're thinking, well, who should we believe? that list, they're thinking, well, if Jennifer's writing all that down, and maybe, there must have been something out there, he must have done something, and that's just not probative, reliable evidence. And before my time runs out, I just want to talk about the sentencing as well, because the trial court gave him the maximum 18-month sentence, and this was not, given even if all the facts are to be believed, and the state's case to be taken into what it is, and the victim is believed and everything, this was not the worst form of the offense to warrant a maximum sentence. There was, when we look, as far as SW, she'd been able to, go on with her life and be married and live a normal life, and she's well into her adulthood now. And I'm not saying that it wouldn't have any effect on her to this day, but the evidence shows that it's not nearly as severe as what we might see in other cases where people have very dysfunctional, where some sex abuse victims have very dysfunctional lives and so on and so forth. And also just the nature of these of a conduct that's accused, it's not nearly as severe as what the courts have seen in other cases where there's a lot more trauma, a lot more violence, a lot more force, and this case does not rise up to that. Therefore, it doesn't justify an 18-month sentence. I think the minimum 6 months, which he's already done, is plenty enough. So I would ask the court that if the court rejects all the first three assignments of error, that at least remand the fourth assignment of error for resentencing, because I don't think the trial court properly evaluated the statutory sentencing factors and was rushing to just impose the max sentence that's not justified in this case. That's all I have.
Questions?
No, thank you.
All right, thank you both for
Thank
your
you.
arguments. We'll take the matter under advisement, issue a decision in due course. Each of you will receive a copy of the court's decision, and when it's released, we'll mail that out to you. And the opinions are also posted on the Supreme Court of Ohio's website.